All right, I will call this meeting of Senate Judiciary to order. Will the Secretary please take the roll?
Senator Harris, Senator Dondero Loop, Senator Orenshaw, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you. Please mark those senators present who were not yet present when they arrive. You know what I mean. Senators Harris and Dondero Loop are here. When others join us, mark them present. And we have two bills up for hearing this afternoon. We will start with AB 75, and I will open the hearing on that right now.
Good afternoon. Thank you, Chair Scheibel and members of the Senate Judiciary Committee. For the record, my name is Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas, and it's always a pleasure to appear in front of this committee. Today is no exception. I have a couple of bills to present today, and here to present Assembly Bill 75 to start. And I have with me to my left, to your right, Mr. Jeff Sailing, who, after I make some introductory remarks, will really take you through the bill. I've been working with him, and we've also been working with the Secretary of State's office, and so we have representatives from that office as well to help answer questions or that you might have. So Assembly Bill 75 deals with everyone's favorite judiciary topic, securities, and it creates a new class of intrastate investor known as the Nevada Certified Investor. And it also exempts from registration certain offers or securities of sales. Now, you may have heard the term blue sky laws. The term blue sky law was popularized by U.S. Supreme Court Justice Joseph McKenna in 1917 when he referred to speculative schemes that have no more basis than so many feet of blue sky. And he was talking about basically fraudulent schemes. And so securities law and protections are generally known as blue sky laws. And so what this bill seeks to do is to make some revisions. Justice McKenna elaborated that blue sky laws are meant to stop the sale of stock in fly-by-night concerns, visionary oil wells, distant gold mines, and other like fraudulent exploitations. Nevada's blue sky laws were written in the 1990s, and they limit who may invest in certain private investments within the state. Again, private investments, not public investments. The purpose of those laws was to ensure that the investor had the knowledge and expertise to participate in these offerings while protecting others without the expertise from the risk of losing their investment. So blue sky laws are really about consumer protection. Nevada's laws, as they exist today, are hardwired to specific federal law and regulatory language related to the Securities Exchange Commission's Federal Accredited Investor. You may have heard that term, accredited investor. Although these federal laws and regulations have changed, Nevada's laws have not. This bill will provide a much-needed update to Nevada's blue sky laws. Essentially, accredited investor means that you are someone with enough wealth that you are given opportunity to invest in private offerings that normal people simply are not. So what this bill seeks to do is open up investing within the state of Nevada to those who don't meet the threshold under the federal law of being an accredited investor. And Mr. Sailing's going to tell you a little bit more about why that's important, what kind of companies we're talking about. So without further ado, Jeff Sailing is here. He is a co-founder and executive director of Startup NV, which is a nonprofit statewide business incubator and accelerator. And I promise you, he only has a few slides, but I think it'll take you through what we're trying to achieve with this bill. And then afterwards would be happy to answer any questions. Thank you so much, Chair, and I'll hand it over to Mr. Sailing.
Thank you, Speaker Yeager. Jeff Sailing from Startup NV for the record, I guess. Sorry if I'm not as good on the all of the formalities. But I'll try to get through the slides and give you some baseline information as quickly as possible. So in terms of what happens with the startup or a new business when they get started, almost all of them go through this process that you see on the slides, starting with an idea, proceeding through, validating the concept, creating an MVP, starting to generate revenue and scaling. Now, companies have to raise money during this process from somebody, usually, unless they've got the money themselves. At the early stages, they're either funding it themselves, they're going through friends and family before they make money, and then oftentimes they can reach out to angels and others as they go through this process. So this AB 75 seeks to allow more people to invest in these companies. So the accredited investor rule from the federal government says that you have to have $1 million of net worth or $200,000 of W-2 income as an individual or $300,000 of W-2 income as a couple. That means that about 9% of the total population of the U.S. can invest in these private companies, and we're at about a third of that in Nevada. And these, I mean, in terms of accredited investors, you know, if you're in California or New York, these people jam the freeways. But here in Nevada, it's a much rarer thing for somebody to meet this criteria. So what we're attempting to do here is sort of make it relative to Nevada, right? Make the standards relative to Nevada. And you hear that term, the rich get richer. You know, it actually is true because only wealthy people have access to these private investments. And they are high risk. The private investments are high risk. But they have high returns when they work. And the protective intentions are admirable for these, for saying only a certain set of people can invest because they're more sophisticated. But I think they've had some unintended consequences in terms of restricting people to invest that otherwise would like to. And on top of that, the businesses here are capital starved. And compared to these other states that we were talking about where there's just more accredited investors who can invest in these companies in these other states. So, on top of all of it, these early stage investments usually are funded by local people. I believe the stat, if you look at any of the sort of the national organizations, the Angel Capital Association, or any other of the national organizations, say 80% of the capital that comes for these private businesses comes from local investors. The number is actually 37 miles. That's where the funding comes from for these early businesses. And so Nevada businesses are at a severe disadvantage because we just don't have enough accredited investors to fund these businesses. So what AB 75 proposes is that Nevadans with a W-2 income above $100,000 a year or above Nevada's median income, whichever is greater, would be a Nevada accredited investor and able to invest. Also, Nevadans who operate a business with gross sales over $200,000 or two and a half times the Nevada median wage would also be able to invest as long as they're investing less than 10% of their net worth. So, and again, as the national standard does, we're seeking to make sure that people aren't going to get over their skis on this kind of an investment. So, and we made the standards relative so that as economics change over time, the standard will change right along with them. It grows the investor base here in Nevada for Nevada-based projects. So we have to stay within the state, of course. And it also should, based on the fact that we're funding these early stage companies, it should create great projects for larger VCs to come in at a later stage when they like to invest in these companies after they've proven themselves a bit, to be able to come in and to the state, establish here, and invest. And from an investor's perspective, it gives you the opportunity to create some wealth where maybe you right now are forbidden from doing that. So this opens up the aperture for investors in the state of Nevada. So I have two examples for you of where this might apply. One of mine, and this is a little bit personal because my dry cleaner went out of business during COVID and we've not gotten a dry cleaner back. So I would love that for somebody to come into that dry cleaner store and say, all right, I'm going to open a dry cleaners. Most of these dry cleaners or these small businesses have an annual revenue of about $250,000. And in this scenario, the dry cleaner business needs about $60,000 to buy the equipment and all the gear and everything else that they need to start their business. So they're going to sell stock in this example because they can for $60,000 or about 20% of the value of the company. And over the next 5 years, this founder operates their business at a 20% profit, $50,000 a year or so, that gets allocated back to the people who invested in them, pro rata for their 20%, at 17 cents a share, or 83 cents over the 5 years. And then at the end, after 5 years, this founder decides to sell their business for $500,000, which they should be able to do easily if they actually are making a profit of 20% on a $250,000 or $300,000 level of income, which means that for every dollar invested by the investors in this scenario, they get $2.50 back over this 5 years. And if the founder's smart, they're probably given some discounts to the people who invested in their company as well, to just make it a little bit more friendly. In this scenario, the founder incurs no debt. Maybe the founder couldn't even raise debt because of whatever their situation is. They weren't a likely candidate to go through the SBA or a bank to get a loan to open their business. And this would allow not only the people establishing the new business to raise from investors that meet the standard, but also those investors who may not meet it from a accredited investor perspective to invest in that business. And I think this will be a really interesting feature for a lot of our chambers of commerce around the state to set up systems like this for the members of their chambers. And the scenario that appeals a little bit more to me from a startup NV perspective, a venture capitalist, so we've got two former students, one from UNR, one from UNLV, a computer scientist and a business grad, and they're going to start some kind of a technology company that's requiring a $250,000 investment to start the company to get them through the first 24 months. Once again, they're going to sell 20% of their company, valued at the beginning at $1.25 million. So 250,000 shares at $1 a piece to probably 500 or 600 different Nevadans who are investing anywhere from a few $100s to perhaps a few $1,000s. And the way these things usually go is if you're successful after your first year or so, you're going to raise another round of capital. And usually you're selling somewhere between 10 and 20% of your company. In the scenario I have before you, they raise $1 million round 2 years from then at a $7.5 million valuation. So a nice 6 times markup from the first valuation. And then they do that 2 more times over 6 more years, eventually getting to the point where 7 years from the time that they started, they sell this company for $100 million. And the founders, because they've sold a bunch of their stock along the way, they don't have the giant share that they did at the beginning. They're down to 30%. The investors who invested with them under the Nevada Certified Investor Rule would be diluted as well. So they wouldn't own the original 20% they owned at the beginning. They'd own 10%. But at a $100 million valuation, for every dollar that those investors invested, they now get $40 back in return. And that takes into account all the dilution and everything else that's a scenario. And that scenario that I just described on that larger scale is what has created so much wealth in Silicon Valley and elsewhere. Because, I don't know, the cool kids, the ones that met the accredited investor standard, could invest. And they had access to these deals. I think we should open up the aperture a little bit and give access to these deals to people that are sort of everyday Nevadans. A little bit sophisticated, but they don't have to be rich to get the rich first before they get the opportunity to invest. And by doing that, we'll have more money for the founders, more money for that investors can invest, and I think we've got a good setup with this bill to make that all happen.
And thank you. If I could, Madam Chair, Steve Yeager for the record. I did neglect to mention in my opening comments that we do have a conceptual friendly amendment from the Secretary of State's office. Hopefully you have that. We made some amendments to the bill in the Assembly, and as sometimes happen, we didn't get those quite right. So we are here with a friendly amendment that make sure that we didn't inadvertently remove some of the safeguards in Nevada revised statutes for other kinds of securities beyond this. So I do have a representative of the Secretary of State's office to help answer questions relative to that. But Chair, with your permission, Mr. Sailing and I would be happy to try to answer any questions you or the committee members might have on Assembly Bill 75 in its first reprint.
All right, thank you. Any questions from members of the committee? Senator Krasner.
Thank you, Chair. Thank you, Assemblyman Speaker Yeager, and thank you, Mr. Saling, for your presentation. This is a great idea, and I'm so happy to listen to this bill. My only question is, why limit it to people who have $100,000? Could there be an exception for people who are worth less or make less than $100,000, but see this as a way to invest their money? I mean, right now, anybody who, somebody who has $10 can invest in the stock market. So it's their choice, or put it in a bank account, for 3%. But why not, invest in one of these privately held corporations if they want to? Just a consideration. Have you thought about it?
Steve Yeager, for the record, appreciate the question, and I see I have some backup coming up to the table. I would just say I think we have to try to draw the line somewhere, right? And so trying to find what works well for Nevada, but my hope would be if we're able to get this passed and it's successful, that maybe we come back and look at adjusting that downward in the future. But I think the answer is probably just we want to be a little cautious. But with your permission, Chair, I would hand it over to my colleague from the Secretary of State's office, who probably has some more he can add on that topic.
Thank you, Mr. Speaker. Thank you, Madam Chair, through you to Senator Krasner. An excellent question, Senator. So to clarify, the language as is net worth of $100,000. As the speaker indicated, it is important to have some sort of level there, some sort of protection in place, specifically because we want to make sure that, when you're looking at someone who has a net worth of $100,000, if they're investing 10% of their net worth in something that has the potential to not necessarily succeed, we want to make sure that we are not setting investors up to fail. Other states, I believe Wisconsin has a similar measure for intrastate offerings. They also have a net worth level of $100,000, and I think that's it. We've discussed similar legislation with them, and they've said that level feels appropriate. And I'm Gabriel DeCare, for the record, Chief Deputy Secretary of State. Thank you, Mr. Speaker.
Senator Hansen.
Thanks. A couple questions. Thanks, Madam Chair. First, isn't it right now under existing law, couldn't I pool money with somebody else? Ira, the poor white boy over here, white trash guy with no money, can I go with several other people and right now create an investment pool and then meet the threshold that the Securities and Exchange Commission currently requires?
Thank you, Senator. Madam Chair, through you to Senator Hansen, Gabriel DeCare, for the record.
You can go direct.
Thank you. Currently, Nevada statute for intrastate offerings, the type this is, where there's no security being sold across state lines, I believe it is 35 or fewer investors. There's no requirement for any sort of registration if you are just doing something similar. And again, this isn't just about fundraising. This is also about the issuing of securities, the issuing of shares, which can be a little more complicated than just pooling money together. And so there is currently an exemption on the books. This bill, as Mr. Saling indicated, is meant to deal with businesses that are looking to do something potentially a little more complex and grow a little larger. And as such, we wanted to make sure that there was a framework in place.
Okay. Well, next question is, SEC currently enforces the existing law. Do we have an SEC or the equivalent for the state of Nevada? And if this passes, who's going to actually make sure that I have the $100,000 threshold of value before I invest?
Excellent question, Senator Hansen, which I am thrilled to answer. So the Secretary of State's office has 8 divisions. The Securities Division is one of them. We have a Deputy Secretary for Securities who serves as the Securities Administrator. Every state has a Securities Administrator. She works very closely with the SEC and assists with the work that they do. But here in Nevada, we have a whole oversight and statutory and regulatory framework in NRS 90, the section of the NRS where this is. We currently have, she's going to kill me, 7. We currently have 7 positions for post-certified law enforcement officers who just do they investigate, criminal securities issues. We this is something that we take very seriously. It's something that the Secretary takes very seriously. We actually have one of our bills, another bill, that would create a Victims of Securities Fraud Restitution Fund, because sometimes if there is a bad actor in a space, that bad actor doesn't always have money to pay victims back. So we take the oversight of securities incredibly seriously, and we're very grateful to the Speaker and to Mr. Sailing for working with us to come up with an amendment on this bill that we feel will protect investors while also providing opportunities to the business community. To answer your question about who verifies that net worth, in our conceptual amendment, we specify that it would be on the issuer, so whoever is issuing the security, to verify that, and that serves as a protection for them just as much as anything else. Our office would almost certainly develop a regulation around what that check should look like and what should go into place, because if someone says, my net worth is over $100,000 and I would like to invest 10% of my net worth in your company, it's not helpful for the issuer if that person comes back and says, you knew I wasn't worth this amount of money. So the issuer would have to verify it, but the Secretary of State's office would work to come up with a standardized process for that verification.
Okay, so you got some checks in place. Last question, though, is if you're going to drop it from $1 million to 100,000, do you expect to see a big spike in the number of people investing? And if that's true, do you have the staff available to manage that?
I think absolutely the hope is that we would see a spike in the number of people investing.
Put your name on the record.
Gabriel
Sorry.
DeCare, for the record, apologies, from the Secretary of State's office. So our office regularly, currently, when businesses file one of the types of filings that they need to with our office, of which there are a number, it's more of a notification. Our office is not necessarily is not going through all of these filings and verifying everything, and that's not just true in Nevada. That's true nationwide. They're notifying us of what they're seeking to do, of the type of business that they're engaging in, of what their process is, and it's only if there is an issue that we need to take that time to begin, the investigation process. So I do not believe that this would require any additional staffing from our office. But Mr. Sailing, if you wanted to.
Jeff Sailing, for the record, just to add on to the commentary so far. Right now, about 3% of Nevadans qualify to make these investments. If you go purely on math, and we had a median income rule, then half of Nevadans would be able to invest. But with the other restrictions sort of layered on top of everything else, the hope would be that we maybe get to a third. When you consider all of the restrictions that are eligible to do it. Now, clearly not all of them will. So again, the idea here is if we could even get it to that 9 or 10 or 12% of the national pool that's doing it, we'd still be way ahead of where we are now, and we could go much further just by following the rules that we've suggested be put in place.
Okay, well, I have some other questions for you. I could take up all the committee's time, but sounds weird, but where's Zach Conine on this one? That guy's my go-to guy on all this kind of stuff. I'm not kidding. Have you guys, anybody heard from the Treasurer's office? He can talk this talk. I can't. So, okay. Thanks, Madam Chair. I'll reach out to Zach.
All right, sounds good. Vice Chair Harris.
Thank you, Chair. So my question is about the income requirement in, I guess it's Section 2, subsection 1, paragraph B. It's about reported income. Is that intended to, is that just the straight up W-2 number? What about adjusted gross income versus modified adjusted gross income, which could often be a lower number? Which number that you report for your income are we going to use for this metric?
Hi. Thank you, Senator Harris. Jeff Sailing, for the record. The idea is to pick a number that's simple and easy to see, right? So we want for the top line number of income, because it's really easy to pick it out off of if you do need to look at somebody's tax return, it's right there in front of everybody, and you can't really monkey with it.
All right, thank you for that. I also wanted to clarify that it is not, in fact, your net worth, but reportable income. Yes.
Gabriel DeCare for the record. Yes, apologies, Senator Harris. There is a net worth requirement in terms of the amount you can invest, but the qualification for investing is in fact that income. Apologies, Senator Krasner.
Okay, just one more, if I may, Chair. I noticed that under the current threshold, there's a difference between a couple and a single person, right? But in this bill, it's just $100,000 for a single person or a couple. Is there any reason why we may want to keep that separate? So whether that be for a single person it's 75 and for a couple it's 100, or whether for an individual it's 100 and for a couple it's 150, right? Is there maybe some reason why that split occurs, or in the converse, a reason why maybe we shouldn't have that income split?
Thank you again, Senator Harris. Jeff Sailing for the record. Again, it was a matter of just keeping it simple, right? Just keeping it really simple. If you're going to invest, you're the person that's in front of me. If you're above the median wage or 100,000, whichever standard you're meeting, it's just easier to do it that way. There's no reason we did or didn't do it other than purely to keep it simple and easy to enforce and understand.
Okay, thank you. I'm going to tip my hand here, and I would suggest that $100,000 for a single person is different than $100,000 for a couple or a family, and you might want to have a slightly higher threshold, even if it's an even nice round number like 150, right, for a couple versus just an individual, especially if what we're looking at is the couple or the individual's ability to take this risk. It's a different assessment. But okay, thank you.
Senator Stone?
Thank you, and thank you for the presentation. I think this is going to create a lot of wonderful opportunities for a lot of people, but I'm just trying to wrap my arms around this. Would this be a partnership? Would it be an LLC? Would it be a corporation? Or is there a mandate as to what the structure is? And can you just address the liability issues associated with the shareholders and what the Secretary of State's nexus is to ensuring that things are done appropriately, if that makes any sense?
Thank you for the question, Senator Sohn. Gabriel DeCare for the record. So my understanding is that there are a number of different entity types that could issue securities based on this legislation, regardless of which type it was, and I certainly defer to Mr. Sailing regarding which types of entities are most likely to issue this type of security. Regardless of what type, is the process for notifying the Secretary of State's office as represented in this amendment is the same, whether it's an LLC or a fund or something else. They would all be required universally to notify our office. But Mr. Sailing, thank you.
Thank you, and just to add a little color, Jeff Sailing for the record. It'll probably almost always be either an LLC or a C corp. The investors, the funds tend to be LLCs. Some of the businesses will be LLCs, but there'll certainly be a fair share. The bigger entities tend to be C corps because they can also attract money from outside the state under the federal law if they're a C corp. It's much easier to do that.
If I may, Madam Chair, just to tag on to that. So that notification process,
With your name.
Gabriel DeCare for the record, that notification process that is identified in this amendment would require the entity to issue three things to the Secretary of State's office. One is a background check. It's a very similar statute to the one that teachers have to go through. Two is a balance sheet for the entity so that they could show the Secretary of State's office where the state of the entity as it stands. And three is compensation for the controllers or the officers of the entity, which is a very normal thing that is also included in other types of security filing. So those would be filed with the Secretary of State's office, but they would also be provided to the investor prior to any security being issued. And so that is to ensure that the investor understands exactly the structure of the entity, who is being compensated and how, but before they make that investment.
That answers my questions. Thank you.
All right, any other questions? Not seeing any. Thank you all for participating and answering our questions. We will move to testimony in support of AB 75. Anybody wishing to give support testimony in person is invited up to the microphones now, but I don't see anybody. So we'll go to the phones for testimony in support of AB 75.
If you would like to testify in support of AB 75, please press *9 to take your place in the queue. We have no callers to testify in support.
All right, then we will move to testimony in opposition to AB 75. I don't see anybody coming up to the tables to give in-person testimony, so we'll go to the phones for testimony in opposition to AB 75.
We have no callers to testify in opposition at this time.
All right, then we will go to neutral testimony on AB 75. I don't see anybody coming up to give in-person neutral testimony, so we will go to the phones for neutral testimony on AB 75.
We have no callers testifying in neutral at this time.
All right, then unless you have any closing remarks, I will close the hearing on AB 75 and open up the hearing on AB 76.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. I am still Assemblyman Steve Yeager. I represent Assembly District 9 in Southwest Las Vegas, and it's a pleasure to present to you Assembly Bill 76, which, as you can see, escaped the Assembly without an amendment, which I'm pretty proud of because most bills get amended. And what this bill does, it deals with recoverable costs of witness fees. I'll just give you a little bit of background information. It's pretty straightforward bill. I'm not going to say it's simple because that's the kiss of death, but it's pretty straightforward in terms of reading it. So the cost of expert witnesses in a civil lawsuit can be substantial, and as such, it's often a significant factor in the overall cost of litigation. In some cases, the cost may be so high that it can impact the ability of a party to pursue their legal rights. If you think about if you're hiring a doctor, for instance, or a specialized surgeon, you're probably going to be paying $1,500 an hour to get them to consult or testify at trial. That's a lot of money, and you can sort of extrapolate that to other professions where folks are not going to come and testify in your trial for free. They want to be compensated, and they want to be compensated at normally their billable rate. So Assembly Bill 76 seeks to increase the amount that's recoverable. You have to be prevailing side in the litigation, so that's number one. You have to win. If you don't win, you don't get your costs. And the last time that this amount was increased was in 1989, so it has been a while. And I want to just take you through the history. There's only really been a couple of adjustments to this number. The very first bill that authorized a court to award the prevailing side witness fees was sponsored by Senator Bill Raggio in 1977, and that was set at $250 in 1977. That amount was increased in 1981. That was a Senate Government Affairs bill. It went from $250 to $750 per witness in 1981, and then in 1989, Assemblyman Callister, who some of you may know because I think he's still practicing law in Las Vegas, Assemblyman Callister and Porter increased it to $1,500 per witness for up to 5 witnesses. Now, I will say, even though it's $1,500 now, the court can already grant more in certain circumstances. If you look at the bill itself, you'll note on page 2, subsection 5, which starts at line 4, and if you go down to line 6, it says $1,500 for each expert witness unless the court allows a larger fee after determining that the circumstances surrounding the expert's testimony were of necessity to require a larger fee. So here's what's happening in real life. Prevailing parties coming into court, and they're saying, we have expert witness fees, and they're always more than $1,500. The parties are having to file motions and brief it with the court, and really the court is almost always granting those motions. So I think by increasing, as this bill proposes, to $15,000, we're going to eliminate a lot of time and burden on litigants to not have to come in for each expert witness above $1,500 and do motions and briefing, and we're going to save time for the court to have to actually look at that because in practice they're being granted already. So, one question you may have is, how did you come up with $15,000? I don't have a great answer for that other than just my experience in court was, if you're going to go all the way through trial with an expert witness and actually prove a case, it sounded like $15,000 was probably the right amount of time when you figure an expert witness has to be retained, they have to do their work, they have to prepare a report, and they have to testify in trial. So I thought $15,000 was a good place to put this. Even if we increase this to $15,000, if an expert witness fees were more, a court could still grant more under the state of the law as it exists now. But I think this just sort of modernizes where we are in terms of recoverable fees of expert witnesses. So with that, Chair and committee members, I urge your support of Assembly Bill 76. This concludes my presentation, and I would be happy to answer any questions.
All right. Anybody have questions? Senator Stone.
Thank you for the presentation. I certainly see the need and the court time that could be saved by all this. So, but this doesn't mandate that they spend the $15,000, right? This is like a ceiling, even though the judge can still even go beyond the ceiling. It's just kind of a guide based on their cumulative time. This is what they get paid.
Steve Yeager, for the record, you're correct, Senator Stone. Let's say an expert witness was retained and they only billed $3,500. The prevailing party would still have to present those bills to the judge. So the judge would not, automatically say we were getting $15,000. It would sort of be the actual cost up to $15,000 by statute, and then if it's more than that, you have to go through that process of briefing and a court hearing and all that.
Any other questions? All right, not seeing any, we will move to testimony. All those, anybody wishing to testify in favor of AB 76 is invited up to the microphones in the front of the room. But I don't see anybody, so we'll go to the phones, please.
Thank you, Chair. We have no callers to testify in support at this time.
All right, then we'll go to testimony in opposition to AB 76. Anybody wishing to give opposition testimony, now is the time, but I don't see anybody. So we'll once again go to the phones.
We have no callers testifying in opposition at this time. Sorry.
All right, then we will go to neutral. Anybody wishing to give neutral testimony on AB 76? I don't see anybody in person. Anybody on the phones?
We have no callers testifying in neutral at this time.
All right, then, unless you have anything you forgot to say, then that will bring us to the conclusion of our hearing on AB 76. I'll close the hearing and move into public comment. Anybody wishing to give public comment is invited to do so in person now, but I don't see anybody, so we will go to the phones for public comment, 2 minutes per person.
We have no callers in the queue to testify for public comment.
All right, then that brings us to the conclusion of our meeting, and we will be here at the same time, same place tomorrow. Until then, we are adjourned.